Don't say anything. Keep your mouth closed and shut up. Today's issue, the Fifth Amendment to the United States Constitution. Don't go away. We'll be right back. The Fifth Amendment to the United States Constitution, which reads as follows: No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia when in actual service of time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment outlines the basic constitutional limits on police procedure, grand juries, and due process of law. Its origin dates back to the Magna Carta, the year 1215. The Fifth Amendment can be broken down into 5 distinct inalienable constitutional rights. 1. The right to indictment by a grand jury before any criminal charges for felonious crimes can be placed against a citizen. 2. A prohibition on double jeopardy. 3. A right against forced self-incrimination. 4. A guarantee that all criminal defendants have a fair trial. And 5. A guarantee that government cannot seize private property without paying the property owner due compensation, the actual market value of the property. Originally, the Fifth Amendment only applied to federal courts. Well, that changed with the ratification of the 14th Amendment, wherein the first 10 amendments to the United States Constitution, the Bill of Rights, were made applicable upon the several states. Grand juries. Grand juries date back hundreds of years to the early British common law. They are deeply rooted in the Anglo-American tradition. The grand jury was intended to protect the accused from overzealous prosecutions by the English monarchy. Now, during the development of the U.S. Constitution, our founding fathers decided to retain the grand jury system as a protection against overzealous prosecution by a central government. The 14th Amendment made the first 10 amendments to the United States Constitution, the Bill of Rights, applicable upon the states. It's important to note that the Supreme Court, in a case called Hurtado v. California, 110 U.S. 516, refused to incorporate the grand jury system to all of the states. This ruling, in my opinion, violates the separation of powers doctrine, as the Supreme Court can only review the constitutionality of a law, not make its own interpretation of the law. Anyway, most states have independently decided to retain a similar form of grand jury system within their state laws and their state constitution. Now, grand jurors are selected from a pool of prospective jurors, and these people must have the ability to serve. At common law, a grand jury consists of 12 and 23 members. Now, since the grand jury system was derived from the common law, the courts have used the common law as its means of interpreting the grand jury clause. Now, the states may set the statutory number of grand jurors anywhere from 12 to 23 members. Today, at the federal level, the law requires the federal grand jury numbers to be between 16 and 23 members. A person charged with a crime that's being investigated by a grand jury, has the right to challenge all of the grand jury members for bias, prejudice, interest, and corruption. This is called challenging a juror for cause. Okay, a grand jury possesses broad authority to investigate any suspected crime. That's before it. However, they may not conduct fishing expeditions, and they cannot hire individuals that are not already employed by the government to locate documents or testimony the grand jury needs to review. A grand jury's job is to make a presentment informing the court of the decision to indict or not to indict a suspect. If the grand jury chooses to indict, it means that the grand jury found that there is probable cause to believe that 1, a crime was committed as charged, and 2, that the crime charged has been committed by the suspect. Double jeopardy. The double jeopardy clause protects an individual against continual harassment through successive prosecutions of the same alleged act. It ensures that an acquittal is final and prevents the state from putting the defendant through the emotional, psychological, physical, and financial troubles that would accompany multiple trials for the same alleged offense. The courts have ruled the double jeopardy clause provides 3 distinct rights. 1, that a defendant will not face a second prosecution after an acquittal. 2, the defendant will not face a second prosecution after a conviction. And 3, that a defendant will not receive multiple punishments for the same offense. The word jeopardy means the danger of being convicted. See, jeopardy only applies as long as a risk of the determination of guilt exists. Self-incrimination. Did you know that 90% of all convictions are made through admissions and confessions? The Fifth Amendment protects a criminal defendant from being compelled to testify against him or herself at trial. In the benchmark case, Miranda v. Arizona, 384 U.S. 436, it's a 1966 case. The United States Supreme Court extended a person's Fifth Amendment protections to encompass all situations outside of the courtroom that involve curtailment of personal freedom, including, but not limited to, all detentions and other custodial encounters with police officers. You know, everyone has heard the Miranda warning. You have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford an attorney, one will be provided for you. Do you understand the rights that I've just read to you? With these rights in mind, do you wish to speak to me? We've all heard that. The right to remain silent applies the moment a person has a substantial and real fear that they are the target of a criminal investigation and that answering any questions without counsel present may be self-incriminatory. You see, any time a police officer takes a suspect into custody, and this includes the mere detaining of an individual for, things like so-called routine questioning, if that person is not free to go, then they are in custody. And the police officer must make the suspect aware of his or her constitutionally protected rights to remain silent and to have counsel present. Now, we'll review the entire Miranda case in a separate video. It's one of the most important cases ever decided. I read it once a year, and I recommend that you do the same. Now, over the years, the courts have slightly narrowed the Miranda rights, holding that police detentions that include interrogations or questioning that occur prior to taking the suspect into custody do not fall within the Miranda requirements. Now, this doesn't mean that the right to remain silent ceases to exist until a person is taken into custody. It just means that a police officer does not have to make the person that they are questioning aware of their Miranda rights until after they have been taken into custody. A person must assert their rights to remain silent and have counsel present the moment that they feel a substantial and real fear that they are a target of a criminal investigation. In a case called Salinas v. Texas, 570 U.S. 178, it's a 2013 United States Supreme Court case. The court ruled petitioner's Fifth Amendment claim fails because he did not expressly invoke the privilege against self-incrimination in response to the officer's question. It has long been settled that the privilege generally is not self-executing and that a witness who desires its protection must claim it. You see, ignorance of the law is no excuse, right? A person also has the right to have counsel present before they make any statement or answer any questions as well. We will cover your right to counsel in the next video, the Sixth Amendment. And as I have said in previous videos on the Bill of Rights, all 10 amendments work together. If law enforcement fails to honor these constitutional safeguards, especially when a suspect has claimed his or her right to remain silent and to have counsel present, unless the prosecution can prove that a suspect has knowingly and intelligently waived his or her right to remain silent, the courts are obligated to suppress any statements made by a suspect as violation of his or her Fifth Amendment protections. When does the waiver occur? An actual waiver occurs when a suspect has made the waiver knowingly, intelligently, and voluntarily. To determine if a knowingly, intelligent, and voluntary waiver has occurred, the court must examine the totality of the circumstances, consider all the pertinent facts surrounding the alleged waiver. If a suspect makes a spontaneous statement before taken in custody, while in custody, and prior to being made aware of the Miranda rights, law enforcement can use the statement against the suspect, provided that the police interrogation did not prompt the statement. It's best not to let yourself get into this situation. The moment the questioning gives rise to a substantial and real fear that the questions are part of a criminal investigation, it's always best to inform the police officer that, quote, I choose to invoke my Fifth Amendment right to remain silent. I do not give you consent to search me or my property, and I do not want to answer any questions until I have counsel present. This is called dropping the exclusionary rule. Now, once a person invokes their rights from that point forward, don't say anything, keep your mouth closed, and shut up! So you can't be prosecuted for something that you didn't say. The Fifth Amendment right can also be lost when an individual voluntarily signs a statement or document. Remember, whenever a signature is required on a document, the signing of that document is always based on voluntary compliance. You cannot be forced to sign anything. And if you are forced to sign a document, that document is immediately null and void because the signature was acquired under threat, duress, or coercion. The courts have also held that to be self-incriminating, the compelled answers must pose a substantial and real threat to witnessing against oneself and not merely a trifling or imaginary hazard of criminal prosecution. 2 years after the Miranda decision, Congress passed a statute called Omnibus Criminal Control and Safety Street Act of 1968. The Omnibus Crime Control and Safe Street Act was nothing more than Congress's attempt to overrule the requirements of the Miranda decision. Some legal scholars felt that Congress had constitutionally exercised its power in passing the act because they believed that the Miranda decision represented a judicial policy rather than an actual manifestation of Fifth Amendment protection. Now that theory was short-lived in a case called Dickerson versus United States, 530 U.S. 428. It's a 2000 case. The Supreme Court, in a 7-2 decision, rejected this argument and held that the Warren Court had directly derived Miranda from the Fifth Amendment. Justice Rehnquist, writing for the majority, wrote, Miranda, being a constitutional decision of this court, may not be in effect overruled by an act of Congress. The court also reasoned that Miranda warnings had become expected in the U.S. Miranda has become embedded in the routine police practice to a point where the warnings have become part of our national culture. The Miranda Court also made it clear that where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. That's Miranda versus Arizona, 384 U.S. 436, and that's at page 491. The privilege against self-incrimination is neither accorded to the passive resistant, nor to the person who is ignorant of his rights, nor to one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be claimed by an attorney or a solicitor. It is valid only when assisted upon by a belligerent claimant in person. That's United States versus Johnson. That's the 76 Federal Supplement 538. In a nutshell, whether or not the police read a person their Miranda rights, a sovereign citizen must understand how to exercise their Fifth Amendment rights, whether they are informed of those rights or not. Due process of law. Now, before the government can deprive any person of life, liberty, or property, the guarantee of due process of law for all persons requires the government to respect and honor all of the inalienable rights, all of the constitutional guarantees, and all of the protections afforded by the U.S. Constitution, as well as all applicable constitutional statutes. Due process guarantees that a person will receive a fair, orderly, and just judicial proceeding. The courts have acknowledged that there are two aspects of due process. One, procedural due process, and two, substantive due process. Procedural due process focuses on the fundamental fairness by guaranteeing a party the right to be heard, ensuring that all parties involved receive proper notification throughout the litigation, and ensure that the court adjudicating the case has the appropriate jurisdiction to render a judgment. So what they're talking about here are the things like, the procedural things like the rules of court, the rules of evidence, that sort of thing. Substantive due process, on the other hand, is the notion that due process not only protects certain legal procedures, but also protects certain rights unrelated to procedure, protecting those substantive rights that are so fundamental that to be, quote, implicit in the concept of order liberty. Just compensation clause. The federal government has the constitutional authority to take private property for public use. The Fifth Amendment's just compensation clause requires that the government pay just compensation, market value, to the owner of the property at the time the property is taken. The U.S. Supreme Court has defined fair market value as the most probable price that a willing but unpressured buyer, fully knowledgeable of both the property's good and bad attributes, would pay for the property. And unless the statute provides otherwise, the government does not have to pay a property owner's attorney fees, only the market value of the property. In 2005, a wildly unconstitutional ruling called Kelo versus the City of New London, 545 U.S. 469, the Supreme Court rendered an extremely unconstitutional opinion in which the court held that a city could constitutionally seize private property for private commercial development where the redevelopment would economically benefit an area that was, quote, sufficiently distressed to justify a program of economic rejuvenation. However, after this insane decision came down, some of the state legislators were forced to pass statutory amendments to counteract this unconstitutional usurp of power in order to protect their citizens from having their property stolen from overzealous corporate fascist enterprises. As unconstitutional as the Kelo ruling is, it still remains valid under federal law. Its unconstitutionally broad interpretation of public use, granting pretended authority to private corporations to seize private property for private commercial development, is just another example of how far down the rabbit hole that we as a nation have gone in allowing those who would pervert our Constitution and gain power over we the people. I am the Ghetto Man. Thank you for watching. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. Please subscribe to my channel, and please share.